Good afternoon. I'm Mark Spognardi. I'm an attorney with Arnstein and Lear, and I'm here to talk to you about the new medical marijuana law in Illinois. I'm doing this on behalf of the Illinois Manufacturers Association, which have been kind enough to invite me here today to speak to you about this important legislation that will affect all employers in Illinois. The proper name of the statute is the Compassionate Use of Medical Cannabis Pilot Program Act. This law was passed in August of this year. We're one of approximately 22 other states in the union that have passed this legislation, and we are touted as being one of the most restrictive of the states that are allowing the medical use of cannabis. And this is a 4-year pilot program that might not be renewed if it proves to be troublesome. Although I tend to speculate that this might be a precursor for decriminalization in the state. The possessed amount that is allowed if you are a certified medical marijuana user is 2.5 ounces in 14 days. That is a lot of marijuana. That is a lot of dope. It must be obtained from a licensed dispensary and licensed cultivation center in the state of Illinois. The dope itself is entirely from within the borders of the state. The state plans on having 60 dispensaries located around the state that are heavily regulated and 22 cultivation centers. The cultivation centers are going to be within each district of the Illinois State Police's jurisdiction. The enforcement vehicles for this will be the Department of Public Health, the Department of Agriculture, and the Department of Professional Regulation. The statute spends a tremendous amount of time granting immunity to those who are involved in the process of administering medical marijuana. Doctors, nurses, caregivers, the patients and users, the cultivation centers, dispensaries, the vendors that would help all of these professionals are provided with immunity from prosecution for being part of the medical cannabis pilot program. The statute also spends a great deal of time explaining that discrimination against a lawful registered user of medical marijuana, discrimination against dispensaries, cultivation centers, and caregivers, doctors and physicians, is prohibited. The prohibited areas of concern in this statute are vehicles, schools and school property, and public places. Essentially, the state regulates the use of medical marijuana to the patient's home or to where they receive their medical care. The purpose of our outline with the IMA is to explain to employers what their rights are. You can continue your zero tolerance policies. You can continue your drug-free workplace policies under this statute. The statute specifically says that you may prohibit use of medical marijuana on your property. You can prohibit the possession of medical marijuana on your property. And you can adopt reasonable rules regarding drug use in general and medical marijuana in particular. The rights of discipline that an employer has include the right to discipline a registered user for violation of the employer's drug-free workplace or zero tolerance policy. This includes the right to discipline an employee for failing a drug test, even if they're a registered marijuana user, if the failure to discipline would result in the loss of a federal contract or federal funding. This is the Illinois legislature's way of giving a nod to an employer who is concerned about losing federal funding or federal contracts because of violations of the Drug-Free Workplace Act. The law clearly states that the employer has a right to prohibit a registered user from being impaired on the job. And the employer may discipline an employee who is a registered user who is impaired on the job. The law specifies in particular those factors that may lead an employer to reasonably conclude that an employee is impaired. They include speech, dexterity, agility, demeanor, irrational or unusual behavior, negligence or carelessness, a failure to meet production standards. Under this law, it's very important for employers to spend time training their supervisors on how to recognize that an employee is truly impaired. There's been too many cases that employers have lost because there was not proper training of the supervisor before the supervisor made the judgment that the employee needed to be pulled off the line because they were impaired. The employer has an obligation to allow a registered user to contest the determination that they are impaired. This is expressly provided in the statute. It's a good business practice anyway to give the employee a chance to give their side of the story. The statute provides employers with legislative protection against lawsuits brought against the employer for actions that it takes to enforce its drug-free workplace policies. For instance, the law protects an employer who takes adverse action against a registered user for being impaired. The law protects the employer from lawsuits from third parties who might be injured by an employee who is impaired. The employer may lose that protection if the employer knew or had reason to know that the employee was impaired on the job and continued to let the employee work. This again is one more reason why employers in Illinois need to train their supervision and management on how to recognize whether an employee is impaired, and why an employer should revise and review its drug-free workplace policies. It's important to note that this law does not preempt or reign supreme over federal requirements prohibiting drug use in the workplace. For instance, Department of Transportation regulations still stand. If you have a driver that tests hot for use of marijuana, they would still have to be pulled from the driving their vehicle. So to summarize employer rights in Illinois under the pilot program, an employer may still prohibit use in its workplace. It can still prohibit possession of marijuana in its workplace. The employer can still prohibit impairment on the job. And in fact, the statute contemplates that an employer will take adverse action against an employee who is impaired on the job. And finally, the employer may discipline a registered user to the same extent that it could register any other employee who is impaired on the job. The difference in the statute, though, however, is that the employer may not discipline a registered user for testing positive on the job for the positive test alone, okay? The only time the employer could do that is if there was a threat of a loss of funding or a federal contract. So how does a prudent, reasonable employer act in Illinois in the face of this pilot program? You need to review and revise your employee handbooks, your employee standalone policies regarding your drug-free workplace or your zero tolerance policies. You need to review your drug testing policies themselves to clarify that testing positive by a registered user in itself will not be grounds for discipline. And finally, an employer needs to train its management and supervision to recognize impairment on the job based on objective considerations and observations. This is very important to afford the employer defense from third parties for an employee who might be impaired on the job, causing injury to others or damage to property. That concludes our presentation today on Illinois' Medical Cannabis Pilot Program Act. I want to thank the Illinois Manufacturers Association for inviting me here today. If you have any questions about this topic or any other employment issues, feel free to contact me at 312-876-7186 or at Spognardi, one word, @arnstein.com. Thank you.